Welcome to the 51st meeting of the Civil Rights Council. The meeting is being called to order. Muriel Block, Senior Fair Employment and Housing Counsel, will conduct the roll call.
Councilmember Hong.
Present.
Councilmember Kish.
Present.
Councilmember Alude.
Present.
Chair Sandoval.
Present.
Councilmember Walensky.
Present.
Great. I would like to thank everyone who is attending today's Civil Rights Council meeting and today's public hearings. This meeting is being webcast live via Zoom video conference, and the video of this meeting will also be available afterwards on the Civil Rights Department website and the CRD YouTube channel. Please subscribe. We also have closed captioning available for participants, which you can find at the bottom of the Zoom bar features. If you are having difficulty accessing closed captioning, you can chat with the administrator to resolve the issue. Members of the public joining remotely may have noticed that you are currently muted and your video is disabled at this time. The Q&A and chat functions are also disabled. However, please be advised that there will be opportunities for public comment and participation throughout today's meeting as we address each of our agenda items. We have a number of ways for you to provide input and comment. You can send an email to the council at fehcouncil@dfeh.ca.gov. We will be checking this email throughout the meeting, and your comments will be read aloud and considered by the council members. If you would like to speak directly rather than through an email, please click raise hand in Zoom or press *9 if you have called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename in the list of options next to your name. We kindly request that you limit your comments to 3 minutes. Department staff members we would like to acknowledge at the outset include Kevin Kish, Executive Director, Adam Romero, Deputy Director of Executive Programs, Rachel Langston, Senior Fair Employment and Housing Counsel, and Muriel Block, Senior Fair Employment and Housing Counsel. Thank you to all those attending. We look forward to your participation throughout today's meeting. We're going to look at the review of the agenda. We have copies of the agenda and meeting materials can be accessed at the council's page of the Civil Rights Department, which is www.calcivilrights.ca.gov. Highlight of today's meeting will include a Civil Rights Department report from the Director, Kevin Kish, consideration of further modified text of proposed modifications to employment regulations regarding criminal history, a public hearing on proposed Fair Employment and Housing Act Fair Housing regulations, as well as a public hearing on proposed regulations regarding Government Code Section 11135. We'll also have updates from the council subcommittees. The first order of business includes a review and approval of the minutes from our last council meeting held in February of 2023, February 21st, 2023. Do we have any comments or edits with regard to these minutes from any of the council members? Okay, any public comments?
No public comments.
Okay, can I have a motion to adopt the minutes, please, and a second?
I move. Helen Hong.
Okay,
I second.
roll call, please.
Councilmember Hong.
Yes.
Councilmember Kish.
Just a reminder that I am a non-voting member of the council.
Apologies. Councilmember Alude.
Aye.
Chair Sandoval.
Aye.
Councilmember Walensky.
Aye.
Great. Motion passes. All right, so the next item is next order of business is a council member's report. At this time, I would like to highlight the exemplary public service of our colleagues, our former colleagues, council members Darius Schor, Tim Iglesias, and Dale Broskis, whose term came to an end on the council. Each of them have had a tremendous and lasting impact on promoting and protecting the civil rights of all Californians while they served on this council, which is consistent, of course, with their life's work and values rooted in equity. It was indeed an honor and privilege to serve with them on this council, and I look forward to continuing to work with them in a meaningful way in the future. I'd also like to thank them again for their tireless work, tremendous public service, and their unwavering commitment to civil rights. So thank you to each of these council members. I'd like to invite other council members also to provide any reports at this time if they would like. Okay, so let's move forward then with a report from our colleague.
Chair Sandoval, sorry, it looks like we do have a raised hand from Dara Sher.
Oh, I'm sorry. Go ahead. Councilmember?
Oh.
Councilmember?
You can unmute, Sarah.
Thank you. I just wanted to say thank you. It was a pleasure and an honor to serve with all of you. And thanks so much to Kevin and all of the staff at the department who were so helpful over the years. So thank you very much.
Thank you. Okay, next we'll have a report from Kevin Kish, the Director of the Civil Rights Department.
Hello, everyone. I just want to do two things today. And the first is to introduce my office mate here in CRD's Oakland office, our newly appointed and now sworn in Deputy Director for Communications, Rishi Khalsa, who joins us today. It's his first day. I'm so delighted to introduce him to the public and looking forward to advancing and protecting civil rights alongside of him.
Yeah, thank you so much for that warm introduction, and just really wanted to reiterate how excited I am to be able to support the work of CRD and the related councils, and just really looking forward to helping uplift this important work and being part of the team. So thank you very much.
Thanks, Rishi. The only other thing I wanted to do today is, like Chair Sandoval, thank and publicly honor the 3 council members whose terms expired since our last meeting, Dara Shore, Dale Brodsky, and Tim Iglesias, each of whom was appointed to multiple terms on the Civil Rights Council. I've had a chance to speak to them privately and individually, but publicly I want to say how impossible it is to overstate or overpraise their legacy on this body. In 2 ways, really. One, in the formal rulemaking, the work they've done, thousands of hours devoted to rulemaking. This work leaves a truly lasting legacy in the evolution of civil rights protections in our state, but also on a less formal and more personal level. Their collegiality, their careful attention to the public and to each other leaves a legacy of performance on this body that I think we all learn from and grow from. I'm so grateful to have had the chance to work with them and for everything that they did for the department, for the council, and for Californians. So we look forward to hearing much more from them in the future.
Absolutely. Thank you, Kevin. Okay, so next item on the agenda. Oh, we have a hand. Helen Hong, council member.
Yes, after we go through the agenda, because we have so few council members now, and when we have many different subcommittees, I was wondering 2 things. One is the newly formed strategic planning subcommittee wasn't on the agenda, so I wasn't sure if that was item number 17, but if we can move that up before we do all the others, perhaps might help then guide some of the reporting moving forward. Just if we can kind of speak to how the council will be moving forward with so few council members, I think will be helpful in terms of how we report out and move forward.
Does anybody have any objections to that movement in the agenda? Okay. I think that's acceptable. All right. So next on the agenda item, we have consideration of further modified text and proposed modifications to employment regulations regarding criminal history. I'll turn that over to my colleague, Councilmember Julie Walensky.
Sure. Good afternoon, everyone. I'll just give a quick overview of where we are in this process. The council issued the notice of proposed rulemaking last May. We had a 45-day comment period and a public hearing. The subcommittee made additional proposed modifications, And then we've had 2 additional 15-day comment periods on those modifications. So today, what we're doing is we're proposing 2 small further modifications after the 2nd-day comment period. And because these modifications could be interpreted as substantive changes, we're asking that the council, today we're asking the council to move this version into another 15-day comment period on these modifications. So that's where we are. We're not currently in a comment period. We're just seeking approval today to start another comment period. So that's where we are. And then I'll just say very briefly what the 2 proposed changes are. The first is to section A45, and that's we propose just clarifying the subsections that it applies to. And the second proposed change is to B6, and here we're just fixing a typo in the cross-reference. The cross-reference is to C 1 through 5, but it should be to B 1 through 5. So that change is just a typo that we're fixing. And also Chair Sandoval and I just want to reiterate our appreciation for all the comments that we've received and continue to receive from members of the public and from the other council members. And we want to acknowledge the significant contributions from Rachel Langston and Adam Romero to the subcommittee as well. So I'll stop there.
Thank you, council member. Any comments or questions from fellow council members? Any public comments?
No public comment.
Okay. Do we have a motion to approve this item for another 15-day comment period?
I move.
Do we have a second?
Second.
Great. Roll call, please.
Councilmember Hong,
Yes.
Councilmember Alude,
Aye.
Chair Sandoval.
Aye.
Councilmember Walensky,
Aye.
Great. Thank you, everyone. We'll now move on to our public hearing for proposed regulations regarding Fair Employment and Housing Act, Fair Housing Regulations. And it is currently 12:13 p.m. We will now begin our public hearing on the proposed regulations regarding Fair Employment and Housing Act, Fair Housing Regulations. We are on the record. Is Monday, April 3rd, 2023. Members of the public can join this hearing through Zoom. Instructions for joining the hearing remotely are available at the website www.calcivilrights.ca.gov. I am Gabriel Sandoval, Chair of the Civil Rights Council, and joining me today are members of the Council, Julie Walensky, Adetunji Alude, and Helen Hong. Although we have made initial introductions, I would like to welcome each and every one of you again today to this hearing portion of our meeting. The purpose of the hearing is to receive public comment regarding proposed Fair Employment and Housing Act Fair Housing Regulations. The overall objective of the proposed regulations is to fix typographical and grammatical errors and provide clarity regarding compliance with the Fair Housing Regulations. This action has a specific benefit of ensuring that tenants, prospective tenants, owners, housing providers, and other relevant individuals better understand their respective rights and obligations with regard to fair housing rights and obligations. Ultimately, the proposed actions furthers the mission of the Civil Rights Department by protecting Californians from housing discrimination. As it relates to housing, the Fair Employment and Housing Act prohibits harassment and discrimination because of race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, familial status, source of income, disability, veteran or military status, or genetic information, or any basis prohibited by Section 51 of the Civil Code. The proposed regulations will amend Sections 12005, 12040, 12042, 12050, 12051, 12140, 12140.1, 12141, 12179, and 12181 of Title II of the California Code of Regulations. Copies of the proposed amendments to the FEHA regulations can be found in Attachment E of today's meeting materials. The notice and initial statement of reasons are Attachments C and D, respectively. The council also has a text of the proposed regulations along with the supporting rulemaking papers on its website. We are holding this hearing as part of our formal rulemaking process. The hearing was noticed through the California Regulatory Notice Register originally on December 30th, 2022. The modified notice of rulemaking was issued on February 14, 2023, and emailed to more than 8,000 individual stakeholders that are part of the Civil Rights Council's email list and published on our website. Pursuant to the notice, we are taking testimony on the proposed regulations here today, and we will accept written comments on the proposed regulations until 5 p.m. today, April 3rd, 2023. You may email written comments to the council at fehcouncil@dfeh.ca.gov. You can also mail written comments care of Rachel Langston, Seniors Fair Employment and Housing Council, the California Civil Rights Department, 22118 Costin Drive, number 100, Elk Grove, California, but mailed comments must be postmarked by today. Please remember that the comments must be emailed, postmarked, or hand-delivered by 5 p.m. today. Thank you for that. Anyone who testifies here today or submits written comments will receive a copy of any changes or amendments that are made by the council, as well anyone else who requests a copy. If there are further changes made by the council to the proposed regulations after today, then the public will have a 15-day period within which to make written comments regarding those changes. We will consider each comment made here today, as well as all written comments received or postmarked by today's deadline. The council will respond to each of the comments in its final statements of reasons, which will become part of the council's rulemaking record. This hearing is being recorded today and will be transcribed. The transcription, as well as all written comments received, will be part of the official rulemaking record. Because the hearing is being recorded, it is critical that anyone speaking does so clearly and that only one person speaks at a time. Please raise your hand virtually and you will be asked to unmute to provide your testimony. Please begin by stating and spelling your name and any affiliation you're here representing. Also, if you are commenting on a specific subsection, identify that subsection so that we may refer to it while you're providing your input. We will hear testimony until all those wishing to testify today have had an opportunity to do so. Are there any questions regarding the ground rules? Okay. Hearing no further questions, we're ready to begin. These proposed Fair Employment and Housing Act Fair Housing Regulations seek to, in addition to other modifications, give meaning to terms used through the Discrimination in Housing subchapter of the FEHA regulations, give meaning to terms used throughout the intentional discrimination article of these regulations, set the general rule regarding notices, statements, and advertisements that are unlawful because they are discriminatory under 12955 of the Act, to give meaning to the terms used throughout the regulations and which concern the Act's protections related to source of income, to add a section to give effect to Sizemore v. Master Finn, which held that the Act's ban on source of income discrimination is not limited to landlords and tenants. Additionally, the section groups together the list of prohibited practices that constitute source of income discrimination in housing contexts other than rental housing covered by section 12141 for greater clarity and ease of interpretation, to describe the permissible circumstances under which a request for a reasonable accommodation or reasonable modification may be denied in order to concisely describe and consolidate a complex body of law into one regulation that provides adequate guidance to the public on the subject that is often misunderstood, and to provide further guidance on issues that arise specifically in the context of reasonable modifications that are not addressed in the existing regulations on reasonable accommodations. At this time, I would like to ask my fellow council members if they have any comments regarding these proposed regulations. Okay, see none, we are now opening the floor for public comments. Would anyone like to provide a public comment? Please raise your hand virtually. If you have a comment, and we also kindly request that you limit your comments to 3 minutes. Do we have any public comments?
None so far. Rachel, do you see any?
No.
Okay. It seems like this public hearing on these particular regulations do not have any public comments at this time. So we are going to adjourn this portion of the meeting at 12:21 p.m. Again, all those who are wishing to provide public comments can do so up to 5 p.m. today. They also have to be postmarked by today if you plan to mail them. All right, so we are done with this portion of the public hearing. Thank you, everyone. Next on the agenda item is another public hearing. And so what I'd like to do is speak a little bit about this hearing. Again, I'd like to welcome everyone. It's currently 12:22 p.m. We're starting the public hearing related to proposed regulations regarding Government Code Section 11135. I would like to welcome each and every one again today regarding the second hearing. The purpose of this hearing is to receive public comments regarding proposed regulations regarding Government Code Section 11135, as I just mentioned. Article 9.5 of Chapter 1 of Part 1 of Division 3 of Title 2 of the Government Code addresses discrimination in state-funded and state-administered programs and activities. Within Article 9.5, Government Code Section 1135 prohibits discrimination and the denial of full and equal access to programs, services, or activities that are conducted, operated, or administered by the state or any agency that are funded directly by the state or that receive any financial assistance from the state. This prohibition applies to discrimination or denial of full and equal access because of sex, race, color, religion, ancestry, national origin, ethnic group identification, age, mental disability, physical disability, medical condition, genetic information, marital status, or sexual orientation. Article 9.5 also establishes procedures for determination and addressing violations of this prohibition. The proposed regulations are to replace sections 11140 through 11200 of the California Code of Regulations with amended regulations set forth in new proposed regulations sections 1400 et seq. Copies of the proposed amendments to the FEHA regulations can be found in attachment H of today's meeting materials. The notice and initial statements of reasons are attached F and G respectively. The council also has a text of proposed regulations along with the supporting rulemaking papers on its webpage. We are holding this hearing as part of our formal rulemaking process. The hearing was noticed through the California Regulatory Notice Register on February 10th, 2023, emailed to more than 8,000 individual stakeholders that are part of the Civil Rights Council email list and published on its website. Pursuant to the notice, we are taking testimony on the proposed regulations here today, and we will accept written comments on the proposed regulations until 5 p.m. today, April 3rd, 2023. You may email written comments to the council at fehcouncil@dfeh.ca.gov. You can also mail written comments, care of Rachel Langston, Senior Fair Employment and Housing Counsel, California Civil Rights Department, at 2218 Costin Drive, number 100, Elk Grove, CA 95758. Costin is spelled K-A-U-S-E-N. But please be reminded that mailed comments must be postmarked by today. Please remember that the comments must be emailed again, postmarked, or hand-delivered by 5 o'clock. Anyone who testifies here today or submits written comments will receive a copy of any changes or amendments that are made by the council, as will anyone else who requests a copy. If there are further changes made by the council to the proposed regulations after today, then the public will have a 15-day period within which to make written comment regarding those changes. We will consider each comment made today, as well as all written comments received or postmarked by today's deadline. The council will respond to each of the comments in its final statements of reasons, which will become part of the council's rulemaking process record. This hearing is being recorded today and will be transcribed. The transcription, as well as all written comments received, will be part of the official rulemaking record. Because the hearing is being recorded, it is critical that anyone speaking does so clearly and that only one person speaks at a time. Please raise your hand virtually and you will be asked to unmute to provide your testimony. Please begin by stating and spelling your name and any affiliation you are here representing. Also, if you're commenting on a specific subsection, identify the subsection so that we may refer to it while you're providing your input. We will hear testimony until all those wishing to testify today have had an opportunity to do so. These proposed regulations regarding Government Code Section 1135 et sec seek to clarify, make specific, and supplement existing state regulations interpreting 9.5 of Chapter 1 of Division 3 of Title 2 of the Government Code. The overall objective of the proposed regulations is to further implement, interpret, and/or make specific Article 9.5. This action has the specific benefits of ensuring the regulation's consistency with current state and, where applicable, federal, case law, statutes, and regulations, and decreasing the number of Article 9.5 violations through providing comprehensive guidance to state-administered and state-funded programs and activities. Does anybody have any questions regarding the ground rules? Okay. Does any council members have any comments regarding the proposed regulation? Okay. Seeing none, want to see if there are any public comments. We are opening the floor for public comments. Again, as a reminder, if you are interested in providing a public comment, please raise your hand virtually. We also kindly request that you limit your comments to 3 minutes.
And Chair Sandoval, apologies, I did raise my hand virtually. I did have a quick comment.
My apologies, I didn't see your hand. So go ahead, Councilmember Walensky.
Okay, I just had a couple of brief comments. First, want to express a huge appreciation to the subcommittee that worked on these proposed regulations, and want to acknowledge their contribution publicly. I had a couple small substantive comments, and I also had some non-substantive comments that relate to potential typos or repeated words. So I'll just say the quick substantive comments, and then wanted to see whether it would be permissible just to email anything regarding a proposed typo to the department rather than going through it here. Is that appropriate? I'm looking at the department.
Do you have a process preference, Kevin?
I think it would be certainly easiest and least time consuming to email it, but that email would likely become part of the administrative rulemaking file.
Okay, thank you, Director Kish, and I appreciate that. I just want to be mindful of everyone's time and want to be most efficient about it. But I did have just some small comments. So the first relates to 1402R20RR on sex and gender. I appreciate the expansive definitions there, and suggest also adding non-binary, since that's a recognized category under SB 179. I think it's contemplated by the definition as drafted, but could be even more clear just to put in the word non-binary there. My second point I wanted to raise is in 14303, which is the section on recording of name and gender, inquiries regarding and recording of gender and name. I wanted to flag in subsection E, there's language about a permissible defense, and I'm not aware of what would constitute such a permissible defense in that context. And the corresponding FEHA regulation does not have a permissible defense. So I would suggest striking the permissible defense language. So those were my substantive comments, and I will send a separate email to be part of the rulemaking record with some tiny additional non-substantive bits. Thank you.
Thank you, council member. Any other council member? Okay. Now we're opening it up to public comments. Do we have anyone who's interested? If you are, please raise your hand virtually and we'll call on you.
First, we have Richard. Richard, you can unmute.
Go ahead, Richard.
Greetings and thank you, Director Kish and council members, for moving ahead on these regulations. Long awaited, and it's just wonderful to see them out there. And I will be submitting later on today more detailed written comments, but I especially my interests come from the intersection of environmental justice and civil rights, and it relates to my background, having worked at EPA until I retired a few years back after 40 years there, the last 20 or so years focused on environmental justice and civil rights, in particular on Title VI of the Civil Rights Act. And I've continued to stay involved with advocates as well as folks at the Environmental Protection Agency and the Civil Rights and EJ program since then. Just a few general comments as you move ahead on this one. I don't know if they're up for adoption today or when that happens, but I urge you to move as expeditiously as you can with adoption and move ahead into implementation, getting some guidance out there, facts, and just practical information so folks in the agencies involved in this can know actually what to do. I want to alert you to being ready to hear from, I'm sure this won't be news to you, but I am still involved with a number of California agencies, especially those involved in environmental justice. You will be hearing from them, where are we going to get the resources? They'll be looking at this as, oh my gosh, an additional requirement. And just to urge you to stick with the tone and a reminder to them that these are not new requirements. They've been around for a long time. They're cross-cutting, they're fundamental, and they actually go across everything else all of these agencies already think they're doing. So they will have resource issues, but they're going to have to deal with that to move ahead, and I hope you'll support that. Secondly, I hope one way or another you'll figure out how to leverage and work with the federal initiatives now under the Biden administrations. There's I think some of you at least are aware of this. There's new leadership, new management, and new policy leadership going on there, especially on the Title VI front. The office has been reformed over there, Office of Environmental Justice and Civil Rights, put together an AA-ship with political leadership will be in place, and a number of guidance documents and that sort of thing coming out. So there's an opportunity here, as some of your agencies, California agencies, are trying to deal with Title VI. It's an excellent time for 11-135 and Title VI to move ahead hand in hand. In fact, it would be sort of counterproductive for them not to move ahead on both of them at the same time. Finally, given the kind of issues I'm involved in the environmental justice front, I'm hoping you'll make use of the existing interagency arrangements, especially the fact that so many agencies related to environmental justice all land over there under Cal EPA, with fairly recent leadership at the top of Cal EPA, a new executive officer at the Air Resources Board. And if I didn't mention before, my background includes 40 or 50 years in professional air quality management. And I know the Air Board is interested in moving ahead on Title VI, probably 11-135. So there's opportunities somewhere in there, working with the feds on one level, Cal EPA on the other, to move ahead on just capacity development and helping them be ready to act. So overall, thank you. To me, this is a very exciting development. The regs look good to me, but what do I know? But it's really exciting to see this. So congratulations and thank you.
Thank you, Richard. And for the record, Richard, can you provide your last name? I'm not sure if you did provide your last name.
Sorry, that's how I signed in. Richard Grow, G-R-O-W.
Okay,
And I'm dialing in from Berkeley, California.
Thank you. Appreciate it. Any other public comments?
Yes, next we have Kendra Muller. Kendra, you can unmute.
Good afternoon. My name is Kendra Muller. I am a disabled queer attorney speaking on behalf of the nation's largest disability rights law firm, Disability Rights California. We are a Civil Rights Coalition member and are in agreement with that written comment proposed and sent in today. Councilmember Walensky, I just want to raise that we also appreciate your proposed changes today. As the Protection and Advocacy Org for California, we are mandated under federal and state law to advocate for people with disabilities. We seek to prevent the discrimination of all protected classes within 11135 and their intersection within the disability space. We are excited and honored to see the work of many advocates over the years come to fruition. The regulations proposed contain much needed guidance and clarifications to combat discrimination for the most marginalized Californians in our community. The Council's care, attentiveness, and receptiveness to experts in the field has led to comprehensive regulations. For Californians who, at this very moment, may live in fear of discrimination, retaliation, segregation, dehumanization, denial of access, or have lived through these painful experiences, these regulations are not only a theoretical framework, but a concrete action that provides protection to their civil rights every day. The state will now have transparent, detailed, and consistent regulations in relation to existing law. We strongly agree with the Council's purpose of instituting these regulations, above all, to protect persons against unlawful discrimination and denial of full and equal access, and ensure that they have a clear understanding of those rights. We believe the proposed regulations taken as a whole do exactly that. I want to uplift and emphasize the discussions of cross-sectional discrimination basis. This is absolutely vital to the regulations. The explicit section on intersectional issues ensures that true protection can occur for Californians. Individuals do not live in an identity silo. Ensuring 11135 implements justice at the intersection of oppression is clear action on behalf of this council to recognize this. This further legitimizes the experiences of Californians across the state. We applaud the liberating wording contained within such a regulation so that it will apply to all Californians. We commend the council's work in including the denial of full and equal access as a protection that is critical to disabled individuals. Their equal opportunity to access the same programs and services as non-disabled individuals recognizes and honors the humanity of disabled Californians. I just want to say today marks historic progress in civil rights justice for Californians. Thank you.
Thank you for your public comment. Do we have any other public comments at this time?
Yes, next person is Puyi Yu. You can unmute.
Go ahead.
Hello, my name is Puyi Yu, and I'm a staff attorney with the Legal Aid Foundation of Los Angeles, which provides free legal services to over 100,000 people living in poverty in the greater Los Angeles area each year. Thank you to the Civil Rights Council for all of the efforts thus far to promote eradication of discrimination in the state of California, which prides itself on being a leader in the equitable expansion of civil rights. In order to maintain this standard bearer status, we encourage the Council to consider our Civil Rights Coalition's recommended amendments to Government Code sections 11135, specifically to sections 14101A through D, as well as changes to the definitions at sections 14020 double L, triple B, and 14100B through F, as set forth in the joint comment letter that was submitted earlier today. We know our state is diverse with nearly 7 million individuals using over 200 languages. At Legal Aid, we've seen that when seeking critical programs and activities, our community members do not distinguish between services provided through federal, state, or local funding. In fact, making such a distinction can be complicated because, for example, the State Emergency Rental Assistance Program involved federal funds administered by state and local governments. Therefore, we advocate for aligning language justice standards among and between the various levels of government so that people in need of accommodation for language access can expect the same level of equitable service across the board. Equitable language access should be the norm so that any individual, no matter the language they happen to use, can meaningfully access critical services affecting their fundamental rights. We should collectively strive to establish not only a standard level of equitable language access across the board, but a high quality one. Our comments to section 11135 reflect advances achieved in recent years with respect to the development of language access plans and policies, multilingual materials, digital access and use of technology, and the importance of stakeholder engagement. This is an exciting time for language rights because there are parallel advocacy efforts in cities and counties statewide, as well as throughout the country. The regulations before us must be enhanced to reflect at least the advances that have been established to date through those tireless yet piecemeal advocacy efforts. No community member should be left to bear risk and loss of health, safety, or fundamental rights due to lack of accommodation to overcome language barriers. Yet service providers often fail to provide community members with language access services on the basis that there are simply not enough people using a particular language. Our regulations should reinforce the importance of an individual's right to full and meaningful participation in society, and we believe our suggested revisions would help achieve this goal. Thank you.
Thank you for your comments. And for the record, can you spell your first and last name, please?
Absolutely. My first name is spelled P-U-I-YEE, and my last name is spelled Y-U.
Thank you again for your public comment. It's appreciated. Any other public comments?
Yes, next is Claudia Center. You can unmute.
Good afternoon, everyone. This is Claudia Center. I am the Legal Director of Disability Rights Education and Defense Fund. And I'm just going to speak briefly as DREDF joined a detailed comment letter, which has already been submitted to the council along with other civil rights agencies and organizations. So I am here just to state my strong support for the draft regulations and for all of the effort that went into the drafting of the regulations. Indicate my support for the coalition comment letter that was just submitted within the past hour. And I'd also just like to call your attention to some coverage issues that I think are very important in section 14020 sub M, which clarifies that 11135 coverage is triggered for any entity, any part of which receives state support. And that is critically important regulatory language. On the federal side, this language had to be put into statute when a number of courts, and then including the Supreme Court, found that only the tiny piece of an entity that received, in that case, federal dollars was covered by the federal analog civil rights statutes. And then that was corrected in the Civil Rights Restoration Act of 1987, which fixed that misinterpretation. So I think we want to avoid that in our state and embrace the federal standard, which has been the federal law since 1988. Similarly, section 14007, which is about the length of time of coverage of 11135, that is also analogous to the regulations implementing section 504, Title IX and Title VI on the federal side. So I think that is critically important as well. I also endorse the detailed definitions of direct threat, qualified interpreter, video remote interpreting, and the comment letter has some important additions and clarifications that we strongly recommend be included in those disability definitions. So I hope you review closely our comment letter, and I thank you on behalf of all of DREDF for all the work that's been done I'm here today, but I'm really here instead of my colleagues who worked on this project, including Sylvia Yee and Michelle Uzetta. Thank you.
Ms. Senator, can you spell the name for the record? I'm going to kindly ask all those to, again, spell the name for the record, but I appreciate your comment.
Sure, absolutely. Claudia, C-L-A-U-D-I-A, Center, C-E-N-T-E-R.
Thank you once again. Any other public comments?
Next is Ashley Werner. You can unmute. Please spell your name for the record.
Hi, my name is Ashley Werner. That's spelled A-S-H-L-E-Y-W-E-R-N-E-R. I'm a directing attorney with Leadership Council for Justice and Accountability, and I'm based in Fresno. I want to say thank you so much to the council for all of your hard work over years now to develop these regulations. We believe that they will play an invaluable role in making effective enforcement of Section 11135 possible. Leadership Council works directly alongside residents of low-income communities of color in the San Joaquin and East Coachella Valleys. The communities we work with are disproportionately comprised not only of people of color, but also residents who speak languages other than English, immigrants, and often families with children and other classes protected under civil rights laws. The communities we work with are impacted by a wide range of historic and severe disparities that deeply impact residents' quality of life, access to opportunity, life expectancies, and health outcomes, and trust in our democratic systems. A few examples of these disparities include a lack of basic infrastructure and services like safe drinking water, functional sanitary systems, stormwater drainage, and reliable transportation options. The concentration of polluting and noxious land uses like landfills, meat rendering plants, and hazardous chemical storage facilities next to homes and schools, and severely dilapidated housing conditions and a lack of housing opportunities. Many of these disparities arose from explicitly discriminatory policies and practices initiated decades ago, and which often continue today in the guise of facially neutral policies. We believe that these regulations will provide communities and their advocates a critical tool to help ensure the realization of their right to live free of discrimination from governmental and private actors and overcome these long-standing inequities. That said, I want to highlight two revisions to the draft regulations, which we proposed in the Civil Rights Coalition letter, which was submitted to you today. We noted that the language in section 1426 could more clearly recognize that programs and activities that negatively impact people based on protected class status, such as where a city directs polluting land uses to Black and Latino communities while shielding whiter communities from such uses through zoning regulations, also fall within the types of discriminatory practices covered by section 11135. In addition, we proposed a change to subsection A10 of that section 1426 to ensure that the language more fully encompasses the various ways in which facility siting occurs and is supported beyond permit approvals. We appreciate your attention to these recommendations. And in closing, again, I want to thank you for your time and your work on these regulations, and we look forward to their adoption and implementation.
Thank you. Any other public comment?
Next is, Cynthia Martinez. You can unmute and please spell your name for the record.
Buenas tardes, miembros del Consejo de Derechos Civiles. Good afternoon, Civil Rights Council members. My name is Cynthia Martinez, C-Y-N-T-H-I-A, Martinez, M-A-R-T-I-N-E-Z. I'm the program coordinator for the Language Justice Initiative at California Rural Legal Assistance, Inc., or CRLA. First, I would like to thank you for your thoughtful approach to the proposed regulations to the state civil rights law. I would like to focus on two aspects that are detailed in the letter signed by CRLA: the use of ad hoc interpreters and machine translations. As an advocate on the ground and someone with personal experiences, I would like to share some with you. So the first qualified interpreter comments are related to subsection LL definition of qualified interpreter, 14100B, definition of alternative communication services. My family's primary language is not English, and I have often seen the power of language through the use of interpreters. Through the years, I've seen my mom at meetings receive only a summary of what was being discussed while working with untrained interpreters. It was like she was seeing a movie about her own life, but she had no control over the script. She could only write a review at the end. But when she had access to qualified interpreters, her eyes would sparkle because it meant that she actually had an active voice in the conversation. As a bilingual person, my family, friends have asked me to interpret endless times, but being bilingual is only one of many skills needed to interpret. Qualified interpreters prepare for assignments, sign confidentiality agreements, take notes, have strong memory retention, learn about laws, ethics, and rules affecting interpreters, etc. They know their role is to use spoken or sign language to transmit a message from one language into another without adding, deleting, or changing the meaning, tone, or register of the message. The regulations should make it clear that trained interpreters are required for all languages, and that untrained ad hoc interpreters or translators are prohibited. The second topic I want to cover is the use of machine translations without review by a qualified human translator. The comments are related to 14100F, subsection of translator. Technology is great and makes our lives easier in many ways, but machine translations still make mistakes because, let's face it, language is complicated, which is why it is essential to have clear guidelines about the use of machine translation and make sure that it is not allowed unless reviewed by a qualified human translator. We don't want to send the wrong message to communities that are already marginalized with a single dangerous or inappropriate mistranslation and lose their trust. Again, thank you for your consideration and thoughtfulness, and I hope that you take these comments into consideration to make these two areas stronger. Gracias.
Gracias a usted. Thank you for your public comment. Do we have any other public comments?
Next is Andrew Menor. You can unmute. Please spell your name for the record.
Good afternoon. My name is Andrew, A-N-D-R-E-W, Menor, M-E-N-O-R, and I am representing Asian Resources, Inc., which is a nonprofit community-based organization established in 1980 with offices in Sacramento and Los Angeles. We are dedicated to providing outreach, education, multiple social services, and advocacy needed in the Asian American, Native Hawaiian, and Pacific Islander, immigrant, refugee, and limited English-speaking communities across California. We want to commend the Council for revising the regulations pursuant to Government Code Section 11135 and to express our support for the proposed regulations. However, we have also signed onto a public comment letter supported by a range of civil rights advocates and organizations to strengthen and clarify many of the provisions in the regulations. In particular, we strongly believe that our recommendations related to the definitions and requirements meant to ensure language access for the diverse communities we serve should be incorporated into the proposed regulations. As the Council is most likely aware, California is home to one of the most diverse populations in the country, with the majority of its population comprised of racial and ethnic communities of color, and over 200 languages and dialects spoken in the state. Almost 44% speak a language other than English, and 19% or 7 million are considered limited English proficient, with close to 40% of its Latino population and approximately a third of its Asian population considered limited English proficient, and almost a fourth of its Latino and Asian population living in households who are linguistically isolated, where everyone over the age of 14 is limited English proficient. Therefore, it's not surprising that many Californians face communication and language barriers by state agencies and those entities funded by the state. We are hoping that these regulations will address and ensure that language justice and civil rights protections are provided to vulnerable communities in California. We've been waiting for these revised regulations for a long time, and we urge the council to incorporate our recommendations and quickly adopt the proposed regulations as soon as possible. Thank you very much for the opportunity to comment on this very important issue.
Thank you for your public comment. Any additional public comments?
Sorry, Thomas Coleman, please spell your name for the record.
Yes, my name is Thomas Coleman, Thomas, Coleman, Coleman, and I'm legal director of Spectrum Institute. We're a nonprofit that has been advocating for access to justice for adults with mental and developmental disabilities in the judicial process, particularly in probate conservatorship proceedings. I've been following the process that the council has had in developing these regulations, and I too would like to add my voice to commending the subcommittee and particularly also the members who have recently left that office, were turned out, for all of the hard work that they did. And I know it's been a long time in coming, but from what I've seen, it's well worth it. The work product is excellent. We submitted a 6-page commentary about various sections of it, and I would like to highlight 2 of them today to give emphasis to it. And I'm giving emphasis to the impact of this on the judicial branch, and particularly the superior courts that operate the probate conservatorship proceedings. I've been monitoring this in quite detail, these proceedings around the state in all 58 counties for many years now. And I'm sad to report that other than providing accommodations to people with who are hard of hearing or deaf, or dealing with physical access issues, wheelchair and access to various parts of the courtrooms, the courts basically are not providing any accommodation to litigants with mental and developmental disabilities to enable them to have meaningful participation in the proceedings and to effectively communicate with all the participants in the proceedings, both inside and outside of the courtroom. The courts process approximately 7,000 cases like this, new cases each year, and there may be 80,000 or more adults that are currently in guardianships, in open, ongoing guardianship proceedings that may last for years or decades. And despite this, the courts still haven't caught up with the times that they have to provide accommodations to people who have mental and developmental disabilities and not just the physical or communication disabilities. So one of the issues I'd like to emphasize today is that dealing with reasonable accommodation. And I'm particularly focused on section 14327 of the regulations. The Judicial Council promulgates rules. Rule 1.100 tells courts what they have to do when someone makes a request for accommodation. Great. But that's not the only way, that's not the only duty that providers of government services or government funded services, that's not the only way that their duty is triggered. Their duty is triggered for known or obvious disabilities. And certainly when someone makes a request, that brings it to the attention of the courts or the service provider. But many people cannot make a request because of the nature of their disabilities. So, and because every single person involved in these proceedings has a qualified disability. The petition says so. The petition alleges as much. There's a record of it and so on. So those that are pre-adjudication have qualified disabilities, and also especially those who have been adjudicated. There's a court order saying that their disability is so severe that their rights have to be taken away. And yet the judiciary believes that it only has to provide accommodations upon request. So, and that is not the law. That is not the federal law. And that should not be California state law, which is supposed to be equal to or provide greater protection than federal law. So I'm suggesting that a sentence be added or some other appropriate way of doing it at the end of this that says, even without a request, an interactive process should be initiated when a qualified disability is known or obvious. So let's put the judges on notice about this, that and court staff and ADA coordinators and so on. And I think that they may rise to the occasion and do what they need to do. Finally, the section 14050 that deals with the administrative complaint process. And I've talked to Director Kish about this in the past, that many of the people who are victims of disability discrimination in probate conservatorship proceedings, they can't file a complaint with the department. They don't know how to. They don't even know that the department exists. They have a serious mental or developmental disability. And so I'm suggesting that the complaint process itself, the council should engage in reasonable modifications of the rules to ensure that people with such disabilities have access to the complaint process. And how do we give them access to the complaint process when they can't file a complaint themselves? And that is by adding the words next friend or protection and advocacy agency. So where it says any aggrieved person or other state agency may file an administrative complaint, just add next friend and protection and advocacy agency, and that gives at least one agency some incentive to speak up on behalf of people who are victims that can't complain themselves, or next friend as federal law allows, and then add a sentence defining next friend pursuant to federal court decisions as someone who's dedicated to the best interest of an aggrieved person who cannot file the complaint on their own behalf due to a mental disability. I think with those two changes and the other few changes that we suggested, it's going to tremendously help clarify the duties of the judicial branch and of the superior courts and other courts to give meaningful access and effective communication rights to people with mental and developmental disabilities.
Thank you, Mr. Coleman. I want to make sure we have opportunity to hear from others, but thank you for your comments, well taken, and also wanted to let you know that you have an opportunity to submit your comments in the records regarding the same by 5 p.m. Today, if you wish. So thank you again, Mr. Coleman.
Thank you.
Any other public comment?
Next, we have Kel O'Hara. Please spell your name for the record.
Hi, it's KELO'Hara.
Thank you. Go ahead.
Hi, thank you. My name is Kel O'Hara. My pronouns are they, them, and I'm a staff attorney at Equal Rights Advocates. We are a gender justice civil rights legal organization based in San Francisco, and we work to address gender discrimination across the life of marginalized folks, specifically in education and in the workplace. We've also participated in the civil rights comment letter that you received earlier today that several of my colleagues have already spoken about. First, I want to echo my colleagues who have commended the council for issuing these proposed regulations and recognizing the importance of them. I'd like to specifically draw the council's attention to one part of our comment addressing the definitions of sex and gender under section 14020 subsections T and RR. Specifically, we are hoping to address or to use these regulations to better account for the rapidly increasing legal threat against transgender Americans, and to deal with the fact that this legal attack often relies on the conflation of sex and gender. We recognize that the proposed regulations definitions refer to the existing definitional framework in FEHA. However, we also know that legal attacks against the transgender community frequently rely on defining gender as an individual's sex assigned at birth. The current definition of gender under subsection T says that gender, quote, means sex. And that is, playing into this harmful narrative that we're seeing. So what we suggest both under subsection T and subsection R sex is to provide more clarity and distinction, including by providing plain, clear definitions of the terms in plain English. We're not proposing that the meaning of the definitions that exist in FEHA and other state laws change. Rather, we are suggesting that you clarify the application of these definitions to safeguard against abuse and manipulation of 11135 and the implementing regulations. To this end, we've also suggested within our comment some further clarification in terms of where definitions are housed, what those definitions say. But in essence, we think that this is particularly important given this political moment, the attacks that we're seeing in our community, and as the increasing threat is happening not only in states, but at the federal level. We think it's really important that California continue to do as we've always done, protect transgender and LGBTQ Americans to the best of our abilities, and that we use the regulations to do so. Thank you.
Thank you, Cal O'Hara, for your public comment. Do we have any other public comments?
Yes, next is Nisha Vyas. Please spell your name for the record.
Hi, good afternoon. My name is Nisha Vyas. The spelling is N as in Nancy, I-S-H-A, last name V as in Victor, Y-A-S as in Sam.
Go ahead.
Thank you. Good afternoon. I'm a senior, my name again is Nisha Vyas. I'm a senior attorney with the Western Center on Law and Poverty. Western Center is a statewide organization that seeks to eliminate poverty and advance racial and economic justice by dismantling and transforming systems so all communities in California can thrive. Our current practice areas include economic justice, including advocating for public benefits, access to healthcare and housing. We provide technical assistance and training to legal services programs across the state as a legal services support center. I want to join my colleagues in thanking the council members and the staff for your comprehensive work on the proposed regulations, implementing and clarifying the purpose and scope of government code section 11135, which is an essential component, as you know, of our state's civil rights statutory framework. Western Center is proud to join with the Civil Rights Coalition, including the legal services advocates providing verbal comments today in the written letter that was submitted today. It has a lot of, there's many comments. Rather than draw your attention to any particular comment, I want to just reiterate, just verbally co-sign all of my colleagues today in terms of their comments, lifting up sections of the letter. And we hope that you can consider these comments in improving an already comprehensive and clearly thoughtful work on the proposed regulations. I'm sorry if you hear my dog in the background. She wanted to comment as well. Thank you.
Thank you. Any other public comments?
Next is Gladys Limon. Please spell your name for the record.
Gladyslimon.
Go ahead, Gladys.
Good afternoon, Chair Sandoval and council members. My name is Gladys Limon. I am an environmental justice and civil rights attorney. I'm the former executive director of the California Environmental Justice Alliance, and I'm providing some brief comments in my personal capacity. First, I want to also thank the council for its work on amending the regulations to our critical state civil rights protections, and also want to commend you for your hard work and the efforts of the committee. I am one of a number of public interest attorneys who engaged in and have closely followed the amendment process for several years, and I've done so specifically from an environmental justice lens. California's civil rights statute and its implementing regulations are of highest importance to communities disproportionately impacted by environmental harms, from the siting of polluting facilities and permitting actions. In many instances, these are the only substantive protections against discriminatory practices or impacts. Otherwise, environmental justice communities many times find themselves limited to relying on procedural protections from other statutes. So EJ communities and advocates are relying on these reasonable and robust amendments. While there are numerous amendments that are of interest to EJ communities, I'll briefly point out that amendments to the definitions of covered entity and amendments in section 14026 regarding prohibited practices, language around selection and permitting of facilities are critically important to clarify that state law meets the federal floor and the analog federal law regulations. Otherwise, the current language without the amendments renders it vulnerable to court interpretation that would narrow the state anti-discriminatory protections, creating a much higher threshold for enforcement by creating a high bar that's a significant hurdle to meet and weakening the state protections vis-a-vis the federal law. So the amendments would clarify the language to ensure that state protections are as strong as current federal protections. The letter from the civil rights community provides additional requested edits to provide some additional clarification to the scope of the protections to ensure that they do not inadvertently exclude highly relevant actions and circumstances. Thank you again for the opportunity to both testify and for all of your work.
Thank you for your public comment. Do you have any other public comments?
Yes, next is Diane Chi Liang. Please spell your name for the record.
Hello, good afternoon. My name is Diane Chi Liang, DIANE-CHI-LIANG. I am from Bay Area Legal Aid. I am a senior housing attorney. Bay Legal serves as the Bay Area's leading provider of legal aid to individuals facing discrimination in housing. Bay Legal's commitment to enforcing federal fair housing laws is at the center of our practice. Bay Legal represents people discriminated against in housing on the basis of race, ethnicity, national origin, gender, disability, sexual orientation, family status, or other protected classes. We have signed on to the public comment letter to the Civil Rights Council, and I would like to bring attention to in particular to the regulations regarding details around qualified interpreters and how they should be utilized, specifically in the context of providing in-language tech support for participants in on-site and remote events, including events through the Civil Rights Department, such as through the Communication Center or the Disability Accommodations Hotline. At this time, neither the Communication Center nor the Disability Accommodation line provide me a multilingual access from the very start of the procedure or the process of filing a complaint.
Any additional comments? I'm not certain if she got cut off or she stopped speaking.
I think that's yeah, that's it. That's all I had to say is
Okay.
regarding that.
Appreciate it. Thank you so much for your public comment. Next public comment, if we have one.
Yes, Fausto Sanchez, please spell your name for the record.
Fausto Sanchez. My name is Fausto Sanchez, community worker for California Rural Legal Assistance in Irvine, California. And my first language is Mixteco. And thank you so much for paying attention to this matter and give me the opportunity to address to you. And my comments for today is related to section 14100, section B, about the alternative communication services. I just want to let you know that, well, I'm from Oaxaca. I speak Mixteco, and I have been served as an interpreter to my family since I was a kid, from Mixteco to Spanish and later on in Spanish to English. And I have seen many many people and many agency governments get frustrated when they hire interpreters to serve them because they have no idea that the Mixteco language is not like Spanish or English. The Mixteco language has many variations. It has three main Mixtecos, which is Mixteco Alto, Mixteco Bajo, and Mixteco de la Costa. And also between those languages, there is 81 variations, which means that if you hire someone who just speaks Mixteco, it's very probable that they are not going to understand the other person without knowing from which town that person is, or from which municipality or state that person is. And that's why I want to let you know that the best way to find someone who speaks the same language is by asking the person the name of his town, the municipality, the district, and the state. And that is how you can find someone who speaks the same language. Because what other agencies are doing is that they just hire someone who speaks Mixteco to work for them. And when they send that person to the places where they are needed, without knowing if the person is from their town, it's very difficult to interpret, or they cannot do that work because they don't speak the same variation, the same Mixteco. And that's why I'm here telling you this, because maybe you can change the system, maybe you can help more these agencies and the government to do a little bit more to find the right interpreter to help the indigenous people. Because there are many people, for example, in California, 35% of them are working in the fields, and many doesn't look for healthcare, or they do not report the crimes that happens to them, or they do not attend the meetings at school with their kids because they're not anybody who can help them. And usually when the teachers or the people in charge from schools look for interpreters, they do not do enough effort to find someone who can help them. They just hire someone who speaks Mixteco. And when this person goes to help them, they do not speak the same language. And that's why I think this is very important to everybody, to find the right interpreter to help the community and to help the indigenous people. Thank you.
Thank you for your public comment. Next public comment.
Archie Roundtree Jr., please spell your name for the record.
Well, good afternoon, Civil Rights Council of the Civil Rights Department Advisory Council. I'm Archie, spelled A-R-C-H-I-E, Roundtree, R-O-U-N-D-T-R-E-E, Jr., J-R, a registered legal service attorney and staff attorney at Justice and Agent. Now, we are a nonprofit legal advocacy organization that uses the power of law to fight senior poverty and to advance equity for all of us as we age. Now, we are a national organization and also engaged in significant advocacy in California. We are appreciative and thankful for the efforts to improve the regulations implementing Section 1135 with respect to age and other protected classes, as Section 1135 is an important tool in fighting systemic discrimination in California. Now, as California's age, the Civil Rights Council has a valuable opportunity to make strategic changes that recognize and effectively stamp out age-based discrimination. We support the proposed definitions in Section 14080 because they ultimately allow for greater recognition of the many ways in which age-based discrimination works. Even, for example, proposed 14080 recognize that age discrimination can occur based on one's actual or perceived age. And this is an important step because discrimination on the basis of one's perceived age is relatively common. Additionally, we also support the updates to Section 14303, inquiries regarding and recording of gender and name, which allow for individuals to be treated with respect and dignity with their correct pronouns. The discrimination felt by LGBTQ+ older adults is particularly oppressive for individuals entering and/or living in a long-term care facility, and it's well documented. Residents of long-term care facilities have to go back in the closet, concealing their identity, and risk facing harassment and discrimination from fellow residents and staff who may use improper pronouns. And of course, the updates to section 14027, standards for determining discrimination and unlawful denial of full and equal access, which recognize the many ways which discrimination occurs in modern times, is a much needed update and will be important to address all sorts of systemic discrimination in the state. The council's inclusion of facial discrimination, intentional discrimination, and disparate impact discrimination allows for those who've been discriminated against, including older adults, to properly assert their rights. Thank you for your time and your consideration for 1135.
Thank you for your public comment. We have next public comment, please.
Next is Kevin Baker. Please spell your name for the record.
Good afternoon, council members. This is Kevin Baker, Kevin, K-E-V-I-N, Baker, B-A-K-E-R. Very briefly, I just wanted to reiterate the gratitude and praise offered by Director Kish at the start of the meeting for former council members Dale Brodsky and Dara Schur, who served as the subcommittee on these proposed regulations. I am the former Director of Governmental Relations for the American Civil Liberties Union in California, and also formerly Deputy Chief Counsel for the Assembly Judiciary Committee. And in both of those capacities, I've had an opportunity to work on legislation regarding this area of the law. I think I may be one of the few people still around, other than Director Kish, who advocated for passage of SB 1442 way back in 2016, authorizing the council to embark on this process. And it is a happy milestone indeed that we have reached this point after so many years. But I really wanted to lift up the work of the former council members. Advocates have obviously offered some helpful improvements, but I want to note that the regulations really are very thoughtful, very thorough, and well-founded in the law, and we will all be well served by their adoption as quickly as possible. Thank you.
Thank you for your public comment. Any other public comments?
There's no further public comments.
I will note, we did receive letters via email, which will be circulated to the council from the following individuals or entities: the Youth Law Center, Family Violence Appellate Project, individual Mary Lindsay, the ACLU, and the Spectrum Institute. I also just wanted to note, since many of our commenters today mentioned a Civil Rights Coalition letter, that of course there's still time to mail it or email it, but to the extent it was sent via email, it has not been received yet. So I just wanted to make folks aware of that, since so many of you referred to it. But other than that, no other public comments via email.
Thank you, Rachel. Appreciate that feedback. I also want to let everyone know that you have until 5 p.m. today to submit your written comments. As we discussed earlier during this public hearing, I would like to thank everyone for participating. The hearing portion of today's meeting regarding these particular regulations is now adjourned at 1:24 p.m. At this time, I'm going to ask if we should take a short break, 5-minute break or 10-minute break. 10 minutes? 5? Why don't we take a 10-minute break? We'll be back at 1:34 p.m. Thank you, everyone. It is currently 1:24 p.m. We ready to get started? Great. It's currently 1:35 p.m. We're back on the record. So I know there was a suggestion to take up item 17 related to regarding additional and modified subcommittee assignments. A little bit focused on next steps. I know that we have several new items to assign committee members to. That includes the new regulations dealing with 11135, as well as the fair housing regulations. And we also have some other committees that currently have one member, and I wanted to just sort of open it up for a discussion related to what we believe are the next steps. We also have formed during our last meeting a particular committee focused on strategy and planning. And at that time, it was Timmy Iglesias, Councilmember Timmy Iglesias and I who were going to be part of that. So I think at this time, I think it's important to get some feedback from council members related to their current subcommittees, and then what next steps are related to these items moving forward. So I know that it's important that we have a strategy meeting and a strategy committee, and wanted to just first discuss anyone's interest in joining me on that particular subcommittee, and that could set the tone for what the council will be doing moving forward, not only related to these subcommittees, but also with regard to our plan moving forward. Councilmember Hong?
So yeah, I would be highly interested in the strategic planning in terms of that subcommittee. I will articulate that I think it would be rather overwhelming for council members to serve on more than 3 committees, because these regulatory packages are quite robust. And without knowing when other council members are going to be appointed and knowing my own learning curve based on their background, I feel like these agendas can be rather intimidating and overwhelming unless we kind of prioritize and reassess what the staff and the council, volunteer council members can really realistically do moving forward.
Okay, so am I hearing that you would want to be part of the strategic planning committee?
Yes.
Any feedback on that particular item? Go ahead, Councilmember Walensky.
Well, I would just echo and agree with the ideas expressed by Councilmember Hong. I would also say that I think that we as a council need to prioritize the current active rulemaking, formal rulemaking processes that are currently in play, especially the 11135 and the fair housing regulations that concluding their comment periods today. So for that, prioritizing the ongoing formal rulemaking projects.
So I agree with that viewpoint as well. I know that the rulemaking package that we are working together on is almost complete. And so that obviously is priority as we move forward to the completion of that particular item. We also have 2 new matters, specifically again related to the fair housing regulations, as well as 11135. Do we have any interest from any of our colleagues to join either one of those committees, 11135, at this time? Councilmember Walensky?
I'm happy to volunteer to join the 11135 subcommittee.
Right. Anyone else at this time? Go.
So I guess if we could just take a step back in terms of so are we looking to staff each of all the current rulemaking that are in play with 2 council members? I'm just looking at the agenda, so I'm just trying to understand kind of like, okay, what's the load going to be? Because
I think the process we can discuss is prioritization, right?
Yeah.
So I think that there's been some agreement that the rulemaking packages that are active should have membership. And then from there, we could discuss the other items that currently have one member, or 2 members, and determine whether or not that is still priority, but not as prioritized as the other items. And I was thinking about going down that process.
Go ahead, I'm doing Go
Yeah.
ahead.
I was just going to say, sort of, they're interrelated on the topic of prioritization, but I think that the UNRU Act subcommittee is one that sort of may stand in the farthest position from the ones we had public hearings on today, and that it might make sense to, I don't know if there's a process of just pausing that committee's work right now, such that, both of us are sort of able to assist with
Sure.
The others. And if that were the case, that sort of UNRU was not one that we were continuing to work on at this point, I'd be happy to also work with Julie on 1135.
Okay. Any thoughts on the religious creed discrimination? Do you have any feedback on that, Councilmember Walensky, in terms of?
Sure. Sure. And so where we are on that committee is that in the January meeting, the council voted to move the proposed draft into the formal rulemaking process, but we have not yet submitted a proposed initial statement of reasons and the rulemaking notice documents to the Office of Administrative Law. And so my recommendation would be that we pause on submitting that until we have a fuller council membership, such that we're not starting the formal rulemaking process when we have such a small number of council members.
Any feedback on that suggestion? Councilmember,
Sorry, I would defer to Councilmember Walensky because that's her committee, and I would support that decision until we have others, so we're not having multiple balls, starting in terms of rules and packages. So I would support that.
Okay.
And I also wanted to add, just responding to what Councilmember Han's question was earlier about how we're staffing these committees where we only have one or no current council members on, but my own opinion is that we really benefit from having 2 council members on every single subcommittee. And just to share for people who are watching or following, because of the open meeting laws, the subcommittee can only talk with each other about the matters of the subcommittee. And we only can talk to other council members who aren't on that subcommittee in this public meeting context. And so I think this activity of rulemaking can't be done without robust back and forth and discussion. So for me, it would be really important to have 2 council members on each subcommittee.
Given what the Councilmember Walensky just said, which I agree with, Councilmember Hong, how do you feel about the algorithm of the bias hearing subcommittee at this time?
Well, I don't know. I'm gonna ask Rachel, has that been submitted for public comment? I think we had approved it to go out, and so I wasn't sure if that was happening next month or if that has already happened. I don't think I've seen anything, so can I ask Rachel?
Yeah, so it has not happened. We're hoping to get it out pretty soon. Getting the ISOR and the full package to OAL. So we were wanting to move forward with that in relatively short order. So that's kind of where we are right now.
So with that, I actually think that we should not pause on that. I think we should move forward on that because we've already gone through so many hearings in terms of just getting it there. I do need a council member on that. I would beg someone to join me. It is really exciting and interesting. And I think based on where we are, especially kind of on a national, like what other places, I think we need to move forward on that.
I'd like to offer a thought here because I agree with everything that the council members have said about the importance of having 2 subcommittee members, but the governor could appoint new council members at any moment. And if we fully staff all subcommittees, then they cannot join them. And so I think there also might be a place to staff subcommittees with one, at least until our next meeting or perhaps the meeting after that, especially since our next meeting is just in a couple of weeks, to see who might be appointed to the council in the coming weeks and months, and allow them to join subcommittees that are within their particular area of expertise or interest. So I do think there's a balancing act to be done here, and I just want to state our department's commitment to supporting the single subcommittee members during whatever time period there is before somebody else joins. And of course, at a subsequent meeting, if it's become overwhelming, we can, the council can vote to add another person, an existing council member to each subcommittee, but I would like to leave some spots open for possible appointees.
Director Kish, are there certain committees in which
well, at the moment, because the algorithm subcommittee has already produced the draft and the full council has voted it into rulemaking, we have to prepare the initial statement of reasons, send it to OAL, have it published in the notice register for an initial 45-day comment period. So there's going to be no work for the subcommittee to do on that for some time. So I would leave that open for now.
Okay.
And I would staff personally the strategic planning subcommittee for sure. The 11135 subcommittee, I do think is a priority for all of us because we've just had the formal hearing and there's significant comments on that.
And what about the religious creed, and were you okay with pausing that one?
I apologize for doing this publicly, but that's what we have to do. And can Rachel and Mariel, can you remind me exactly where in the process we are with religious creed?
We have prepared all the supporting documents for that, and they're ready, but I think we're waiting for the appointment of new council members to review.
I see, but the full council has voted or not voted that rulemaking?
The full council has voted to move it into formal rulemaking, but we haven't yet submitted anything to OAL to start that process.
I see, right. So similarly, I see.
Yeah.
Well, the reality is the council's vote is valid for as long as you don't revoke or change the vote. So it can sit there on pause for as long as it needs to in order to allow you to do the work that is prioritized. So on that one, you know, I think it's fine for us to simply say the council, the subcommittee will move it forward, instruct us to move it forward at the time that it makes sense to do that. But it's certainly fine to wait for new appointments on that.
Okay. How about with regard to the fair housing regulations? Anybody have interest in serving in that capacity at this time?
Well, considering that there's only 4 of us, and Julie and then TJ has the other ones, I guess you're staring directly at me, then Chair Sandoval. I'm happy to.
How many committees will you be on?
That will be 4, but I think if you and I are both on strategic planning and community education outreach committee, maybe that one, it will kind of subsume into our bigger strategic plan possibly. I mean, I just want to do more than 2 regulatory packages that are moving at the same time, and that's going to be my max, right? Like, I don't think it's fair in terms of expectation and time that I can dedicate. But I don't see we need to, and so I'm happy to support in my capacity to do so.
The other thing that I would suggest is that on the fair housing regulations, because it is essentially a cleanup package that is mostly technical in nature as opposed to substantive, that depending on the staff I can work with our staff to present at the next council meeting what we think the council, what we propose the options are for the council, depending on whether and what public comment we receive today, without creating a new subcommittee.
Okay.
Again, that conversation will be public, but that's the nature of the body.
And where are we with the update of the reasonable accommodations for associational disabilities subcommittee?
We've not voted on text as a committee, as a council, sorry. We are still waiting on information to be able to progress with that regulatory package.
So maybe that's another one that we could put on pause. The hate violence subcommittee, I'm wondering if that could just be either combined with the community education outreach committee or part of the strategy. Thoughts? Anybody have thoughts on that?
Well, I think I would agree because now we have the other board that it's really kind of a parallel, so it's not as active. So I would support that. But that was real. Well, actually, no, but that's yes. That and that would defer to you, Gabriel, because that was you've been the most active, and I think have led that.
Yeah, I want to make sure that we don't lose it, and that there's some way to still work with the commission, and so that may mean that we leave the community education outreach subcommittee intact, and then incorporate the violence related issue, hate violence related issues into that.
I think that's a good idea.
That work? Okay.
Sorry to jump back. So Director Kish, talking about the technical FIHA nature, if you want, if it's the most expeditious so that staff don't have to coordinate and there is no benefit to have a council member, I think that would be great. I will just offer up if they just want a clean set of eyes to review that aren't not looking at it, I would be happy to do that without a subcommittee. So is that helpful in any way?
Incredibly helpful. I think it is ideal to have an appointed council member look at it before it comes back. So if you are willing to do that, then I think that we should put you on the subcommittee and you will be the person.
That sounds great. So I'll be the Lone Ranger, and I'm happy to just be the clean set of eyes and really lead the technical cleanup for the staff, and then I will help kind of guide that through the process under staff's expertise.
Okay, so just so we're clear on where we are, Fair Housing, Helen Hong will be serving in that capacity, assisting that way. 11135, we have council members Julie Walensky and Adetunji Alude. We have, we're gonna put a pause on the reasonable accommodation for associational disabilities subcommittee. Of course, we're moving forward with the criminal history and employment regulations subcommittee. We are combining hate violence subcommittee with the community education outreach subcommittee, and that's going to be continuing with Helen Hong and me. We will, as I understand, we'll move forward with the algorithms and bias hearing subcommittee because it's moving forward. We're hoping to have some new council members by the next couple of meetings, and maybe they could join that particular item. The UNRU Act subcommittee is on pause. As I just mentioned, the update from Community Education Outreach Subcommittee will be moving forward, incorporating hate violence as a topic. Where do we land on the religious creed and discrimination? Is that moving forward? No, at this time?
I think it's just keeping it on hold, leaving the opportunity for staff to move forward, and then hopefully another person when we have new council members. Is that what I think I recall?
Yes. And then we have a subcommittee newly formed, formerly with Councilmember Timmy Glassman to me. Now it's Helen Hong and me dealing with strategy related to the council.
From a procedural standpoint, Kevin, do we need to like vote on these new combined things? And so maybe let's do that and then we can.
Do we need to do that piecemeal, Director Kish, or can we just make one reference back?
I
to
believe it is within your power, but my colleagues will correct me to recite what you just recited and propose it for a single vote.
Okay.
In other words, you just recited into our public meeting the subcommittee assignments.
I did.
And you could call for a motion to vote those subcommittee assignments.
Great. So as Director Kish just mentioned, I identified new subcommittees and combination of subcommittees, as well as subcommittees that are going to be paused for the time being, with anticipation of new appointees to the council, and we could discuss this issue again in the near future, hopefully. And so, as described, do we have a motion to adopt the new subcommittees and the consolidations of some subcommittees as described? And I'm more than happy to go over them again, but I think it's in the record. Do we have a motion?
So moved.
Do we have a second?
A second.
Right. Roll call, please.
Councilmember Hong,
Aye.
Councilmember Alude,
Aye.
Chair Sandoval.
Aye.
Councilmember Walensky,
Aye.
Great. So at this time, because we took this out of order, do we have any updates from any of these subcommittees that we just went over? Anybody have any?
May I pose a question actually, before we do that? So
Sure.
in sort of consequent agendas, is there going to be something that notates which subcommittees are on pause, or will they be sort of listed in the same fashion where an update is being asked even of the ones that we're putting on pause?
There's some discussion as to whether or not they should be agenda items moving in the future, so they may not show up as agenda items if they're on pause. Again, this is a deliberative process and ongoing process, so we feel there's a need in the future to bring back and actively work on a particular item under these particular subcommittees that are going on pause, or there may be new areas of interest that we can identify, but it's really up to our decision or discussion moving forward. But I think moving forward, we will not have them listed as agenda items. Does that work for everyone? Yes, okay.
It does.
All right. All right, so just I want to ask, is it possible for just me to ask if there's any updates, generally speaking, with regard to any of the agenda items? Given our discussions, update on reasonable accommodations for social disabilities. Do we have any updates there?
No.
Okay. Any public comments?
no public comment.
Okay. Any updates? We heard from Julie Walensky, Councilmember Julie Walensky, about the Criminal History and Employment Regulations Subcommittee already. Any public comments on that?
No public comment.
Okay, we're going to the next item. With regard to update from Hate Violence Subcommittee, I don't have any updates regarding that subcommittee. Do we have any public comments?
No public comment.
Okay. We're moving up to the update from the Algorithms and Bias Hearing Subcommittee. Do we have any updates?
No updates.
Okay. Any public comments?
No public comment.
All right. Any updates from the Unruh Act Subcommittee?
No.
Okay. Any public comments on this item?
No public comment.
All right. Update from the Community Education Outreach Subcommittee. Any updates, Helen? Hong?
Nope, not for me.
Okay. One update is that it's now going to incorporate hate violence issues. Next, we have the update from the Religious Creed and Discrimination and Accommodation Subcommittee. We've discussed that as well, but do we have any updates on that?
None other than what we've already discussed.
And then I skipped if there were any public comments on the Community Education and Outreach Subcommittee 15. Do we have any public comments there?
There were none.
Do we have any public comments with regard to item number 16?
No.
Okay. And we had the discussion already regarding additional or modified subcommittee assignments. Do we have any further public comment?
No public comment.
I will just add that since the hearings, we have received 2 additional letters of public comment.
Okay.
One from National Housing Law Project on the housing regulations. And then we did receive the Civil Rights Coalition comment letter on 11135. So just wanted to put folks' mind at ease that it did come through.
Thank you, Rachel. And I would like to thank everyone again for participating today at our council meeting and our public hearings. Oh, Councilmember Hong.
Could I just make a request from staff? While this is much more fresh and with my notes from the public hearing, can you just upload the letters to our shared file so that I can try cross-referencing it? Just because I've looked at the package, we have the public comments before our next meeting because I won't remember it all. I just put it all in my own notes right now, if that makes sense. If you can share those to the committee, to the council sooner than later.
Sure. I think we've created kind of new files with within the respective, comment, respective regulatory package folders. So we will share those respective files with the comments in them, if that works.
Perfect. Thank you so much. I appreciate that.
Sure.
Great. Thank you, everyone. Have a good rest of the week. Thank you to the members of the public who provided comment during today's council meeting and public hearings. This meeting is now adjourned. It's currently 2:02 p.m. Thank you, everyone.
Thank you.
Take care.